Hello guys, Dusty here. Let's talk about trademarks. Did half of you just fall asleep? Well, if trademarks are not interesting to you, and this whole debacle with the Fine Bros and Sony and Let's Play and that kind of thing does not interest you, I'd highly recommend, going to another video, maybe one with cats in it. But, if you're kind of interested in this stuff, I have a doozy for you. A fantastic, fun time. So let's get started with, first of all, a nice little preface here. And that is, I am not a lawyer. I do not have any degrees pertaining to law. I do not work in a legal profession. Well, I do not work in an illegal profession either, but I do not work in a law profession. So, at the end of the day, do not take my advice as legal advice. Take it as information as pertaining to trademarks and how this has to do with particularly the Fine Bros debacle. Now, first of all, the Fine Bros debacle. What the heck is going on? So basically, the essence of it is the Fine Bros tried to, trademark the term react. You wouldn't believe how stupid that'll sound at the end of this video. In fact, you might already believe how stupid that sounds. But yeah, they tried to trademark React, and in essence, they were trying to at least make a network where they could use their assets, like the word React, in your YouTube videos. So that's in essence what's going on. That's in essence what has happened. They have now actually, as of the time I've made this video, dropped their request for the trademark. However, still, I figure I might as well talk about it and how it's screwed up that they tried to do this in the first place anyway. Not just that it's wrong to other YouTubers, but how dumb they were for even requesting the trademark. Because they weren't going to get it anyway, and it was just going to cause a whole bunch of problems. So, also, I do want to say that trademark is not to be confused with copyright. Copyrights are an entirely different thing, and I might talk about them in a future video. And then, also, a lot of the information I am using, I am not just spouting things out from the top of my head. I am using a source called cyber.law.harvard.edu.metaschool.fisher/domain. So I'll have a link to it in the description. So there, I won't have to say the whole entire freaking URL now. So to get started, I figure I might as well talk about what is a trademark, because a lot of you guys are like, what's a trademark? Why is this? What's going on? Why is this so important? And now a trademark is, by definition, a trademark is a word, symbol, or phrase used to identify a particular manufacturer or seller's products and distinguish them from products of another. So, in essence, for example, Coca-Cola. Coca-Cola is a trademark. And Coca-Cola, in essence, basically means this is Coca-Cola. This is Coca-Cola brand Coca-Cola. All right? So it's not Pepsi. You can't call Coca-Cola Pepsi. Well, you can if you're from the South, but Pepsi can't call Pepsi Coca-Cola. You can call it if you want, but I mean, whatever. But yeah, basically, moral of the story is a trademark is something used to identify something. And now, there is also another kind of tangent called service marks. They're also trademarks, but they're also service marks, which identify a certain service that is protected under trademark law. For example, Jiffy Lube is protected under trademark law. But we're going to go into a different subject here called what kinds of trademarks are there? Because honestly, a lot of people don't know. There's multiple different kinds of trademarks. In fact, there's 4 of them at least. So we're going to talk about these different kinds of trademarks. Now, they're called, the first kind is arbitrary or fanciful. The second one is suggestive. The third one is descriptive. And the fourth one is generic. Now, the first one is arbitrary or fanciful, and basically it bears no logical relationship to the product that this company sells. For example, when you think of Apple or Kodak or Exxon, nobody even knows what an Exxon is, but we all know what an apple and a Kodak is. A Kodak's a bear and a apple's fruit. But when I said Kodak, Apple, and Exxon, you probably thought about gas, apples, and pictures. That is a fanciful or arbitrary trademark. And those are highly protected. Apple has a very easy to protect trademark because they have Apple in the tech industry. They can own Apple. They have it. That is their name. And it cannot be confused with another product. All right? So, in essence, that is that example of that trademark. So, the Fine Bros React doesn't fit into that trademark, right? Because it has a lot to do with what the video's about. So next is a suggestive trademark that evokes or suggests a characteristic of the underlying good. For example, copper tone. Copper tone kind of has something to do with sunscreen, right? But it's not copper tone. It's not a product called copper tone. Now, the next type of trademark is a descriptive mark, a mark that directly describes a characteristic or quality of the underlying good. Like, for instance, Holiday Inn or All-Brand. It's a characteristic of the product. All right? So that can be protected. It's not necessarily easy to protect, but it can be protected. And it has to have acquired second meaning, which in essence means when you ask the public what Holiday Inn is, they're not going to tell you it's an inn for holidays. They're going to tell you, oh, it's a chain of hotels. That's basically secondary meaning, all right? But determined by the court, it's basically they did a whole bunch of test groups and asked a bunch of people if Holiday Inn is synonymous with hotels or for, holiday inns. So then next, a generic mark, all right? This is the fourth kind, and this is a mark that describes the general category, like React, all right? This is React. This defines perfectly what React is. A generic mark is a mark that describes the general category for which the underlying product belongs. How can you disagree with that being React? Now, listen to this. For example, the term computer. It's the same thing, right? It's a computer. It's a generic term for computer equipment. Generic marks are entitled to no protection under trademark law. Therefore, Fine Bros cannot trademark React. I just legaled all of you guys. Yeah. So that's why they could not get the trademark. In a long-winded 7-minute explanation of why they could not get the trademark. Now, I am also going to talk about a little bit more on how they went to obtain this trademark, or how anybody obtains a trademark. So, how do you get a trademark? Assuming that the trademark qualifies protection, which it doesn't. React does not qualify as a trademark because it is a generic term. Rights to a trademark can be acquired in one of two ways. First being the first to use it in commerce, which Fine Bros doesn't sell reactions. They don't sell a React product, even though you could agree that their video is a product as pertaining to React. Still, it's a generic term, not protected. But the second way is to register that mark with the U.S. Patent and Trademark Office, which is what the Fine Bros tried to do. Okay? Now, descriptive marks, they go on to say, qualify for protection only if they have acquired secondary meaning, which is what I talked about earlier. For an example, Holiday Inn. That's what Holiday Inn means. It's a chain. Everybody knows Holiday Inn is a hotel chain. All right? It's not a inn for holidays. So next, we're going to talk about how to lose a trademark, and this one's a doozy. All right. So first of all, a trademark is abandoned when it is used. When it is not used anymore, when it's discontinued. All right. So, for example, Game Boy. This is actually really kind of interesting. Game Boy is going to be the trademark's going to be gone. Nintendo will no longer own a trademark on Game Boy because of basically they abandoned it. And now a non-use is basically the same thing, except it's prima facie, or correct until proven otherwise, evidence of abandonment. So, pretty simple. And my computer just died, so I will be right back. Now, another way to lose a trademark, and this is the whole thing where, remember how I said they were planning on doing a React, basically, multi-channel network, or MCN, where they could use the term React in their videos? When the use of a trademark is licensed without adequate quality control, which in essence means you can't just hand it out to anybody who will pay you, all right, or supervision, that trademark will be canceled. So even if they obtain the trademark, it would have been canceled. Sure. Or if they give the trademark out to another party and grows. For example, a multi-channel network. So, yeah. Anyway, we're going to go ahead and talk about trademark infringement now. Nice little segue there. If a party owns the rights to a particular trademark, that party can sue subsequent parties for trademark infringement. Another reason why they couldn't enforce their trademark. They're not going to sue everybody who makes React videos. They're not going to sue everybody who makes React comments. They're not going to sue everybody who reacts to things. They're not going to do that. So in turn, they can't enforce it. All right? Now, another thing is, honestly, they friggin' I'm sorry, this is just so ridiculous, but the fact of likelihood and confusion, all right? Likelihood of confusion. There's nobody who's going to frickin' confuse their React videos with other people's React videos, all right? They have their own, like, look and branding and stuff like that, their own people. Nobody's going to confuse a product, so it couldn't be protected in that way. So basically, that's really all I have to say as pertaining to trademark law with the Fine Bros debacle. Now, in essence, I'm going to talk about a little bit why it was wrong for them to have done this. Now, believe it or not, they are not only the first not the first people to make React videos. People have made reaction videos, except they've titled them either under reactions or like case studies or something like that. But they were trying to take that for their own, something that they do not possess, which is our right to do a certain genre of video. And this is going to talk about Sony a little bit. They were trying to take Let's Play, which once again, let's first of all check. What is it? Is it a generic trademark? Is it, what kind of trademark would it have been? Was it a generic, descriptive, suggestive, arbitrary, or fanciful? Well, the answer is pretty simple. I sound like a BuzzFeed article. Since it describes a general category to which the underlying product belongs, it is a generic trademark which cannot be enforced. So that was easy, right? So even if they got the trademark, they would have gotten a generic trademark and couldn't have enforced it at all. So they wouldn't have gotten the trademark in essence. Yeah. So basically, why is this happening? I'm going to say now. Why? Why do people not read into trademark law before applying for a trademark? You're just throwing money down the drain. Well, honestly, the trademark system can be abused. You can have anomalies. A good example for this is King trademarking the word saga in video games. They did that a while back. If they did that, how can I not do that? How can I not go out and frickin' get Let's Play or get React? All right? So basically, they've done it priorly. So now everybody's trying to apply for trademarks that they shouldn't be able to legally obtain. Just like King shouldn't have been able to obtain Saga. Because what do you think of when you think of Saga? All right? You think of Star Wars, if you're normal. So if Lucasfilm or Disney tried to do that, could I see no problem in them going out and doing that? I mean, I suppose they could. They could do that. Now, another aspect is, like, the Captain Sparkles debacle when he was trying to make his one video game, and Bethesda basically said, oh no, you cannot have Fallout in your title. I think his game was called Fortress Fallout or something like that. You cannot have Fallout in your title. Well, what do you think of when you think of Fallout in video games? You think of Fallout, right? So that is an example where a trademark works, all right? And that is justified. So as much as Captain Sparkle fans might hate me saying this, that was justified for Bethesda to have done, all right? That was an example of properly using a trademark, basically. Now, could it have caused confusion? Probably not. But still, they own that trademark. They own Fallout in video games. It was just like if I frickin' made a game called The Amazing Mario Brothers or The Amazing Zelda. You would be able to tell that, that's probably not a Nintendo title, but still, Zelda is owned by Nintendo, all right? It's their registered trademark. They're entitled to it. So I can't argue with stuff like that. But stuff like frickin' React, that is something I can argue with. And that is basically explaining why they could not get this trademark in the first place. And why at least they shouldn't have been able to get the trademark in the first place. So I hope that kind of enlightened some of you guys. Now, if you have any questions, let me know in the comments. I will answer all of your questions in the comments if you comment. Come on, challenge me. Ask me as many questions as you can. And, try to ruin my entire weekend. And it's already Wednesday, I suppose. But anyway, thank you guys for watching this quick video. And maybe if you like this video, let me know, and I'll do a video about copyrights or something like that, and why the YouTube Let's Play scene is getting so barraged with copyright claims. And YouTube stuff in general is getting barraged with copyright claims. I will do an entire video on that, and it'll be, if you guys want to see it, it'll be more researched and, better put together. But anyway, thank you guys for watching, and I will see you all next time. Take it easy.